Oh yay, oh yay, oh yay. The Honorable Supreme Court of Arkansas is now in session. All persons having business before this honorable court, draw near, give attention, and ye shall be heard. May God save these United States, the state of Arkansas, and this honorable court.
Good morning. The court has cases to hand down today. Justice Baker.
CV-19-929 Charles Edward Jones versus the state of Arkansas from Pulaski County Circuit Court, 4th Division. Petitioner's pro se second petition to reinvest jurisdiction in the trial court to consider a petition for writ of error quorum nobis. Motion to show cause. Petition denied. Motion to show cause treated as a motion to supplement. Petition to reinvest jurisdiction and denied. Justice Hart dissents. CR 20-294 Donald Capel versus the state of Arkansas from Pulaski County Circuit Court, 7th Division. Affirmed. Justice Hart concurs in part, dissents in part.
CV 20-83 Maurice Trammell versus Wendy Kelly, Department of Corrections from Chico County Circuit Court. Affirmed. Justice Hart dissents.
Will the clerk please read the submissions?
There are 12 appeals being submitted to the court for decision this morning, the first of which will be our oral argument. Civil case 19-929, Jennifer Jones, in her official capacity as clerk of the District Court of Benton County, Arkansas, versus the Professional Background Screening Association. This is an appeal from Pulaski Circuit. We also have criminal case 20-249, Michael Collins versus the state of Arkansas from Pulaski Circuit. Criminal 20-291, Alfonso Hampton versus the state from Bradley Circuit. Civil case 19-700, American Honda Motor Company versus Larry Walter as Director of the Department of Finance Administration from Pulaski Circuit. Civil case 19-907, Coppers Incorporated versus Kelvin Trotter and others from Pulaski Circuit. Civil case 19-918, Douglas Companies, Inc. versus Larry Walter as Director of the Department of Finance Administration from Pulaski Circuit. Criminal case 20-297, Edmund Lewis versus the state from Howard Circuit. Civil case 19-516, Michael E. Ray versus Wendy Kelly as the Director of the Department of Correction from Lincoln Circuit. Willie Gaster Davis Jr. versus Wendy Kelly in her official capacity and others, an appeal from Jefferson Circuit. Civil case 20-178, Alonzo Watson versus Dexter Payne as the Director of Department of Correction from Lincoln Circuit. Civil case 20-195, Andrus Hall versus the state from Lee Circuit. And finally, civil case 20-296, Luther Lewis versus Dexter Payne from Jefferson County Circuit Court. In addition to those 12 appeals also being submitted to the court this morning are 18 various motions and petitions, all of which are available on the court's website.
Okay, thank you. Our case for oral argument is CV 19-929, Jones versus Professional Background Screenings Association. And the court will recognize the appellant.
Thank you, Mr. Chief Justice. Good morning, and may it please the court. My name is Jennifer Merritt. I'm a Senior Assistant Attorney General, and I represent Jennifer Jones, the clerk of the Bentonville District Court. I have reserved 5 minutes for rebuttal. The Professional Background Screening Association's attempt to secure a ruling from this court for its members that the Arkansas Freedom of Information Act governs their request for case records to the Bentonville District Court, not this court's rules for access to compiled information in Order 19, fails for both lack of a justiciable controversy and on the merits. PBSA is not an Arkansas citizen and has no rights under the FOIA. And PBSA and its members have never requested compiled information or records under Order 19. All of PBSA's claims therefore fail for lack of standing, and its federal claims seeking retrospective declaratory relief are also barred by the 11th Amendment and for failure to exhaust administrative remedies. Should this court reach the merits of PBSA's FOIA claims, it should reverse the circuit court's FOIA rulings, because on the undisputed facts of this case, the Bentonville District Court staff do compile information from multiple case records by selecting and aggregating information when they respond to background check requests due to the nature of their PTS software system. And on the merits of the cross appeal, the court should affirm because Order 19's rules on access to compiled court information and records, as applied by Clerk Jones, do not clearly and unmistakably violate federal law. Now, as I mentioned, the FOIA claim fails at the outset because PBSA is a foreign corporation. By statute, only Arkansas citizens may request copies of public records under the FOIA, and only Arkansas citizens may appeal the denial of a FOIA request to circuit court. That's Arkansas Code Annotated Section 25-19-105-A2A. This is fatal to PBSA's FOIA claim. The circuit court reversibly erred in addressing the FOIA claims on the merits and in ordering Clerk Jones to respond to a FOIA request. Now, Mr. Ramey will probably talk a lot. Yes, Your Honor?
Ms. Merritt, I wanted to look to the commentary of Order Number 19, and it references that information to be compiled needs to be reformulated or aggregated into a new court record. And I'm wondering if you can describe to me how the process by which the clerk would engage in getting this information to PBSA, how that would reformulate or aggregate information to create a new court record.
Yes, Your Honor. So with regard to the Order 19 claim, which is a separate Section 1983 claim that PBSA raised under federal law, I was trying to address the FOIA claim that with regard to reformulation or aggregation, what this court has defined.
We need to start, I think that's a good place to start the conversation, is with FOIA versus Order 19 and talking about really the definition under Order 19 and then looking to our commentary, if you don't mind.
Absolutely, Your Honor, I'm happy to do that. So, of course, Order 19 court has to start with the language of the rule that controls. And so Order 19, Section 3A defines compiled information as, quote, information derived from the selection, aggregation, or reformulation of information from more than one court record. So that is a controlling definition, and the court must look at the undisputed evidence about the process of responding to court records in the Bentonville District Court and whether that process fits the court's definition for compiling information. And we submit that it absolutely does because court staff are selecting and aggregating information. The court defines court record as, quote, both case records and administrative records, but does not include information gathered, maintained, or stored by a non-court agency. So the definition of court record is information and records. Similarly, a case record is any document, information, data, or other item created, collected, received, or maintained by a court agency, or clerk of court pertaining to the administration of the judicial branch of government.
Ms. Merritt, how specifically in this instance, when Ms. Jones was going to her software, to her computer to find this information, how specifically was she reformulating or aggregating information? I mean, it's definitely a multi-step process, and I think that the circuit court referred to it as an antiquated process in Bentonville District Court, and that it was cumbersome. But I just want to know specifically how was that information being reformulated?
Our position, Your Honor, is not that it's being reformulated, but they certainly are selecting and aggregating information from more than one case record. And so what the clerk described, and when reading back through the briefing, I apologize if it wasn't quite as clear as what it could have been. So what they are doing, and as she has described in her affidavits, the multi-step search process is essentially resulting in the creation of a daily docket sheet. So the way the PTS system stores records, Your Honor, is not by a case name, not by person's a case number. So when these records, background screening companies send the request, they just send a name and a date of birth. That's the
But
only.
is it not specific just to the Bentonville District Court?
Well, this case is an as-applied challenge to the Bentonville District Court. So that's what this case is about, is an as-applied challenge. The federal claims as well as the FOIA claim, okay? So this case is solely about how the Bentonville District Court is responding to these requests. So
Right. But the way by which that information is gathered, that doesn't transform the substance of really what we're looking at here, the nature of the information. It's just specific to how this particular district court and the software it has chosen to use is leading to a very difficult thing for the district court clerk to do in this instance.
It's not transforming, so to speak, but it is creating a new set of records, which, as this court explained in the per curiam opinion when it adopted the administrative order, when you're using court sources, whether that is personnel, whether that is a software system, which is the PTS system, to create a daily docket report. So the daily docket report generates a list of all the case records for every matter that the district court judge heard on that particular day. So for that particular hearing date and type, whether it was arraignment hearings that were heard that day. So every case that the judge heard that day is one document. So court staff have to manually scroll through that document and find, for example, if the subject of the records request is named as Joe Smith, the clerk staff have to manually scroll through that document. Let's say it's a 100-page document. They have to scroll through and only find the specific case record that relates to the subject of the request. And then they print only those few pages, and then they add it to a pile. And then they go on to the next criminal record. And as the case was undisputed, that multiple or many individuals who do have records in the Bentonville District Court have many offenses and cases that are responsive. And the Bentonville District Court system also has 3 separate databases. They have a database for the city of Bentonville, one for the Bella Vista, and then one for the state of Arkansas. So when they are reviewing and trying to locate responsive records when they receive these requests, they have to create the daily docket. They have to scroll through and identify, select, print, and then create a set of records. I'm sorry, Your Honor?
Well, if this system and software, if it were more up to date, if it were easier to use, if there were less scrolling that had to occur from the clerk's standpoint, would this be a different case?
It could be a different case. You know, this is an as-applied challenge, Your Honor, and when the court is addressing an as-applied challenge, the court must address the facts as they exist. And so this system was put in place in 2002, and Order 19 was adopted in 2007. So the system predates Order 19.
So in some district courts, you're suggesting it might be a situation that falls under Order 19, but in other district courts, it could be a FOIA request.
It could very well be, Your Honor. Absolutely. This is an as-applied challenge. And so the court has to look at the situation and the process for responding to the request in this specific court, given the system that they have. And under, Section 1 of Order 19, the court has a lot of concerns that were at play. And one of them is, effectively using court recesses and court resources and not unduly burdening the ongoing business of the judiciary. And, there are some facts and some information, even in PBSA's brief, where they're talking about, only 10 to 20% of the names that they submit to the Bentonville District Court are going to have responsive information, but they also submit a lot of requests, Your Honor. So over that 1 week period in February of 2018, that's really what gave rise to this dispute, was in February of 2018 when Clerk Jones initially asserted that these requests are really governed by Order 19. And that they needed to submit a compiled records request pursuant to this court's order, and PBSA's member, Courthouse Concepts, declined to do that for some unknown reason. Yes, Your Honor.
So in the specific case here, this individual, do we know, did he have more than one case? More than one criminal case? Do we know that?
The subject of the FOIA request from July of 2018,
Yes.
the record does not show that, Your Honor. With regard to the
let me ask you, because it seems to me the first thing the circuit judge had to do was decide whether the order applied or FOIA applied, right? So our commentary says, the commentary actually has section 3, A10 recognizes compiled information is different from case-by-case access because it involves information from more than one case. So it says compiled information is information from more than one case. So if the circuit judge assessed if this request on this individual involved information from more than one case, according to our order, administrative order applied, and that would end it, he wouldn't move to FOIA. But that analysis didn't happen.
Correct. With regard to the FOIA case,
Right.
the FOIA claim, the court has found, with regard to the overall case, that the FOIA issue controlled, and the court simply ordered production under the FOIA and entered judgment in favor of the state or Clerk Jones with regard to Order 19. The Order 19 claims fail for a lot of other reasons too, with regard to standing and rightness, the overall claims, because they've raised, in addition to the FOIA issue, they are claiming it's broader. The Section 1983 claim is broader. They are claiming Clerk Jones' interpretation of Order 19 burdens their ongoing future rights to access, but not one member has ever submitted a compiled records request under Order 19. They have never exhausted any administrative remedies. They are seeking a declaration that Clerk Jones' decision in July of 2018 to not provide records, that in of itself was a violation of Order 19. That's a request for retrospective declaratory relief, as the 8th Circuit held in the Justice Network versus Craighead County case, 931 Fed 3rd 753 from last year. That's a retrospective relief that's barred by the 11th Amendment. So there's a lot of reasons why their Section 1983 claim, which was count, I think, 1 and 3 of their complaint, why that claim is absolutely barred as a matter of law for a number of reasons. So the court should affirm the circuit court's judgment in favor of Clerk Jones on the Section 1983 and the federal law claims as a matter of law. And the FOIA claim should have failed out of the gate just simply for lack of standing. I don't think the court ever needed to reach the merits and address whether, in fact, the subject of the July 2018 request had multiple court records or not, because the particular plaintiff in the case that they filed has no FOIA rights at all. And we raised that in our motion to dismiss, in our summary judgment, and they could have easily added courthouse concepts. I mean, their president was, submitted affidavits in support, and they just never did that. And the circuit court just erred as a matter of law when he address those issues on the merits.
Ms. Merritt, let me ask you this question. Assuming that the standing is not an issue, and PBSA had requested one record under FOIA, would the clerk have the responsibility of copying that and giving it to PBSA?
Yes, Justice Wynn, one record. So Clerk Jones testified. If they had come in and they said, we have a traffic citation and here's the citation number, please provide that. She said, absolutely, that is a different situation. And absolutely, Justice Wynn, she would have provided that. That's not a request for compiled information. What makes these requests for compiled information is, again, going back to the plain language of the court's rule. They are selecting and aggregating information from more than one court record because they're asking for all of the available information from multiple case records, and the case records that exist, Your Honor, are mixed in with other people's case records that are not responsive to the request, if that makes sense. I hope that's clear to the court, because I think my brief was a little bit muddy, and I do apologize for that. The responsive records are mixed in with a bunch of other folks' records, and they've got to pick those out and only provide the responsive records, and that creates a new curated set of records that does not exist in that form anywhere. So this is in fact a new record that's been created specifically for them.
Ms. Merritt, so the PBSA had asked for over 800 different records, correct?
Yes.
Yeah. So
that was over 4 days. And I'm sorry, I cannot see the clock, Madam Clerk. I don't know what my time is. And
let me ask, because I'm asking a question, if you could answer this question. Let's assume that they want 840 different records on defendants. Had they come in on 842 different times, would that clerk under FOIA make copies for the requester?
If they knew the case number and they had a citation number and they weren't having to go dig needles out of haystacks, I believe that would be a different case, Your Honor. But that's not the situation here, and that's not the facts presented here. The situation here is they don't have a case number. They don't know whether responsive records even exist. They're just sending lists of names. And that 840 names, Judge, I think that actually was 4 days worth of requests. And so on PBSA's numbers, it would have taken them, I think I calculated, if it takes them 10 minutes a name and only 20% of the folks have records, that was like 26 hours of labor. That's just 1 week. It's extremely burdensome. And those are the kind of interests that this court had when it adopted those compiled records requests. And I don't want to eat into my rebuttal time, and I just don't see that.
Ms. Merritt, let me further ask, isn't it a clerk's responsibility to provide those records? And as you've indicated, if it took 26 hours or 40 hours, the clerk is entitled to bill the requester for those hours and for making copies, correct?
Not under the FOIA, Justice Wynn. The FOIA absolutely prohibits the clerk from billing for personnel time. They're only allowed to bill for the actual cost of reproduction, which specifically excludes personnel time. But under Order 19, they are allowed to recoup those costs. And that's why it makes such a big difference in the Bentonville District Court specifically, which is the hometown of Walmart and all of its suppliers. This court is uniquely burdened by background checks.
And I understand how arduous it would be, but that's not the argument. The argument is legally are they entitled to it?
If it's a valid FOIA request, but this was because of the way they have to compile the records in this specific instance, Justice Wynn.
Thank you. Thanks.
Thank you.
Okay, the court will now recognize the appellee's attorney.
Thank you, Mr. Chief Justice, and may it please the court. My name is Travis Ramey, here today on behalf of the appellee and cross appellant, the Professional Background Screening Association, or PBSA. The trial court correctly determined that the requests PBSA members make for court records associated with individuals are not compiled information under Order 19. The trial court erred, however, when it granted summary judgment to Ms. Jones on PBSA's claims related to its members' First Amendment and common law rights. Although this case does raise some other issues, and of course yielding to the court's questions, I'd like to focus on, time permitting, 3 of the issues. First is the correct interpretation of Order 19. That seems the most logical place to start. Second are PBSA's members' rights to access court records. And then the content-based restrictions in Section 6B5 of Order 19.
Well, counsel, since you're going to start there, administrative order says it applies to all court records. And I think that Justice Wynn was sort of, hitting the nail on the head, is it's not a question of denying access, that these are public records. And so it's the question of the entitlement, whether it's under FOIA or Administrative Order 19. And it's quite a burden in whether they're entitled to sort of charge for the burden that sometimes comes in. And so, hypothetically, if the Arkansas Bar Association sends over and says they want an email address of every single licensed attorney in Arkansas, and one by one, our clerk's office has to pull that and provide that takes, can shut us down for a week for 8,000 lawyers to be able to, that's what Administrative Order 19, and it's the judiciary's power to, why isn't it the judiciary that can set up the parameters for access to court records versus the legislature sets up access for other records?
Justice Wood, let me begin by saying under your hypothetical, where someone requests a list of every email address of every attorney in the state of Arkansas, we don't dispute that would be a request for compiled information.
Well, I'm saying one by one. So they send over one by one.
Well, again, the question then would be, is there an existing court record that without modification or reformulation or aggregation contains that information? If the answer is yes, then it is not it's not compiled information under Order 19. If such a record does not already exist, it is. If there is an existing court record that has this information in it and the request is for just the record, that it is not compiled information. That is the distinction that PBSA is drawing. And it complies with the way in which Order 19 and its commentary defines compiled information. Compiled information is about information. It's not about extant court records.
Counsel, let me ask you this. So, the John Doe or the individual, they asked on one individual, if he had 5 case records that they then sent back, his 5 convictions, that's multiple case records under administrative order. The commentary says that's compiled information, right?
Well, I think that the definition of compiled information is more complex than just more than one record from more than one case. And again, it talks about information and not records. The textual definition talks about information derived from selection, aggregation, or reformulation of information from more than one court record. So it's defined in terms of information. Commentary is even more explicit. It's information from more than one case. Only some of the information. It has to have been reformulated or aggregated. And yes, it does involve the use of court records to identify, gather, and copy the information, but it's not just copying all the information. It's the creation of a new record that did not previously exist.
So counsel again, so the one individual, if he had 5 convictions, but one of them was sealed, so they had to redact part of one of them and hand over the 4. So now they've given multiple cases, which is what our compiled definition is. So I think what I'm walking you down the path that the circuit judge did not have the information in front of him to make the decision, which is why administrative order says you ask the circuit court, you ask that court, if you're denied and you think you needed access and it was wrong, then you appeal and you go to the committee, which your complaint says you didn't do on this occasion, the injured party. Your complaint says, I think on page 10, that it was in another case in another court that you went to the committee.
Well, Your Honor, I have 2 answers to your question. The first is that even under your hypothetical, I don't believe that's compiled information because there would still be no reformulation or aggregation of the information from the records. And there would still be no creation of a new court record. So that's my first answer. My second answer would be the Committee on Automation's jurisdiction is limited to denials of requests for compiled information. And PBSA's position is that our request is not one for compiled information. Given that that's the case, the Committee on Automation would not have any role in declaring whether a request is or is not for compiled information. Simply
So wasn't that what the original dispute was about, was whether or not their assessment that it was compiled information was accurate or not?
Yes, Your Honor, that's correct.
Okay.
And if PBSA is correct that this is not in fact compiled information, then the Committee on Automation would have no role in the process at all. If it's not compiled information, it's not subject to any of the limitations in sections, I think 5 through 9 is what Order 19 states. And if that's the case, then textually under Order 19, FOIA then governs the request. That's the correct procedure. To give an example of, perhaps this would be helpful to give an example of what would be a request for compiled information. If a PBSA member came into the Bentonville District Court and said, please provide us with a list of everyone who was charged with a DUI in 2002. I doubt that there is an extant court record in the PTS system listing everyone charged with DUI in 2002. To put that list together, the staff at the Bentonville Division would have to go through multiple court records for multiple cases. It would have to derive or extract information from those records. It would have to reformulate and aggregate that information and then create a new court record. That would be compiled information. And
Counsel, what's the difference between bulk then? Because to me, that's a description of bulk data. And Amendment 19 there's a difference. There's bulk data and there's a process and there's compiled information.
Well,
so
I agree, Your Honor. And I'm sorry, Your Honor, go ahead.
What's the difference then between the two? Because that seems like a bulk data request.
Well, Your Honor, I agree. I think that the bulk distribution rules are sort of the limiting principle on how many records a PBSA member can come in and request. But bulk distribution talks about a significant subset of the information in court records as is and without modification. So if a PBSA member came in and said, please provide the judgment in 63,000 cases, that's bulk distribution. It's asking for a significant subset of the information in the court's records in its extant form. That is the limiting principle here. But Ms. Jones has not asserted that the requests PBSA are making, even the 840, are bulk distribution. Her argument throughout this case and the letter she received in advice from the AOC is that these are compiled information requests. And simply put, they don't meet when you're requesting existing court records. That is not compiled information because there's no reformulation or aggregation of information that is extracted from the records to be compiled into a new court record. That doesn't textually meet the definition. And earlier AG opinions interpreting FOIA, which also has regulations on compiling information, sort of recognized that difference, saying if we have a production of existing records, that's not compiling information. Compiling information is taking information from existing records, putting it all together and to create a new document. That is what it means to compile information. So yes, PBSA members may request multiple records from multiple cases, even as to multiple people. But the Bentonville Division can respond with court records that already exist. And because they can respond with records that already exist, they don't have to extract or derive information from records. They don't have to reformulate and aggregate that information, and they don't have to create a new court record. Therefore, textually, it is not a request to compile information. Now, Ms. Jones' argument really is that because PTS has this complicated search process, that alone transmogrifies the request from being one for court records into being one for compiled information. But the complexity of the PTS system, the fact that it may be antiquated, doesn't change the nature of what PBSA members are asking for. They're asking for extant records. And I'd point the court to section 4B of Order 19, which says that the form of storage or the form in which records are maintained is supposed to be irrelevant to the application of Order 19. So the fact that the PTS system may be old and hard to work with doesn't change the nature of what PBSA members are asking for. Now, we agree that there would be a need to identify, gather, and copy records and use court resources to do that, but that isn't alone enough to make this a compiled information request. If I came in and asked for 2 records from 2 cases where I stated the case number and even the date of the documents, the court would still have to use its resources to identify which specific court records I'm asking for, gather them together, and copy them for me. That can't be enough alone to make it compiled information. To interpret Order 19 that way would make it just absurdly broad. It was also inconsistent with how AOC treats Court Connect, where I can log on today and run a search for Justice Rhonda Wood by name. And Justice, I assume you probably wouldn't return any records, but if you did, AOC would allow me to download all of them if I wanted to, and it would not require me to sign any sort of compiled records license agreement in order to obtain that information. I also think there's sort of 3 overarching principles that confirm that PBSA's reading of Order 19 is correct. The first is there's a strong historical policy in favor of maximum access to court records. That's embodied both in the common law of the state of Arkansas, but it's also embodied in the text of Order 19 and in FOIA itself. Second, to the extent that Order 19 does restrict access to extant court records, it's in derogation of the common law. And the court's precedent is clear that items that are in derogation of the common law are supposed to be construed narrowly. And third is, and this sort of is a nice dovetail to the items that are brought in the cross appeal, PBSA's interpretation of Order 19 does not raise this potential host of constitutional infirmities that Ms. Jones' interpretation raises. And generally, when faced with 2 reasonable interpretations, one that raises constitutional difficulties and one that does not, we would choose the one that does not raise constitutional infirmities. If, I will say, if the court agrees with the circuit court's interpretation of Order 19, it may not need to reach any of the right of access under the Constitution and common law questions or the content-based restrictions. The canon of avoidance suggests that those issues should not be decided on the merits. If, in fact, PBSA members have a statutory right to access these documents. But if the court reaches those issues, then I think we start with the First Amendment right of access to records. Many U.S. courts of appeals and lots of states have agreed that there is a qualified right to access court records under the First Amendment. Now, I agree with Ms. Jones, it's not an absolute right, it is qualified. But the way we know which records to which that right attaches is we apply the experience and logic test, which the Eighth Circuit has blessed specifically in terms of the constitutional right of access. And this court has blessed, at least as it deals with the constitutional right to access court proceedings. And what we are talking about here, since we're talking about criminal records, in the in re search warrant case, the Eighth Circuit said we're talking about records that are integral to the criminal process. And it doesn't seem to be controversial from decisions nationally. And we cite some of those on page 63 and 64 of our brief, and then the Reporters Committee cites additional cases on 21 and 22 of their amicus brief. It doesn't seem to be terribly controversial that the criminal records PBSA members would be seeking, like docket sheets, charging instruments, documents reflecting disposition of charges, would satisfy this experience and logic test.
Mr. Ramey, I'm going to back up just a little bit. Weren't you saying in a general sense that the 1983 claims should be dismissed?
Yes, Justice Hudson, that's correct. Under the canon of avoidance, it would have what would have made the most sense would have been for the circuit judge to say, I have determined you have a statutory right to these documents, and that the type of record requests you're making don't fit within Order 19. It's compiled information provision, so they're FOIA requests. Therefore, I don't have to decide any of the constitutional questions. And that being the case.
But the circuit court went on to address those in granting a partial summary judgment. And Clerk Jones, her position is that at that time you did not make the argument you're making now about being maybe dismissed as moot or maybe a lack of ripeness. And so I wanted you to address that she says this isn't preserved because you didn't argue that before the circuit court.
Your Honor, I would say that my understanding of the way we argued these issues in the circuit court is it was always an either-or situation, that the constitutional claims only really attached if we did not have a statutory right. Now, I do have to concede that at the summary judgment hearing, when the circuit judge said, I'm granting X and Y, there was no stand up and object, but our reading at that point was that the circuit judge had already granted judgment. I don't know of a requirement to file a post-judgment motion at that point to ask him to withdraw his summary judgment in favor of a dismissal. Had the judgment having been rendered, if it was rendered improperly, our reading of the situation was that our relief was on appeal at that point, as there was already going to be an appeal anyway.
If this court were to agree with you and to affirm on direct appeal and then getting to the cross appeal, and if this court believed that you didn't preserve your argument, would it still be troublesome for the court or advisory for us to weigh in on those 1983 type claims? Would it be more prudent for the court to address mootness or ripeness in spite of the fact that you did not specifically address that to the circuit court?
Justice Hudson, if I understand your question, I think it is problematic to have this extant question out here about whether the way Ms. Jones is applying Order 19 complies with constitutional requirements for access to records, and whether Section 6B5's purpose-based requirements violate the content-based rules as laid out in the Reed v. Town of Gilbert decision. Yes, I think that is problematic. And if the court does not conclude there is a statutory right to access those documents, it may be prudent for the court to reach that issue anyway. I have, according to my clock, about 1 minute left, and I do want to touch on a very quick policy issue, if I may. It's background checks are important. 96% of employers do them, including the state of Arkansas, for the record. 90% of employers use court records to do them. In the CDIA and NCRA amicus briefs, pages 5 through 10 and 7 through 11, respectively, there's discussion about how court records and background screening are important, sort of what some of the dire consequences can be. If ultimately this court's conclusion is that PBSA members are not entitled to access to these records under the Order 19 as it exists, then we would certainly urge the court to address this through rulemaking and modify Order 19 such that it can create a path for background screening. The court could also do that to address Ms. Jones and smaller courts' concerns about the amount of fees that they're able to charge for this.
Counsel, is there a reason that you think that if the court found Administrative Order 19 applies, that it suggests that you won't have access? Isn't it just sort of what Justice Wynn said? It's a question of whether you have to pay if it takes more than an hour to compile it?
Mr. Chief Justice, my time's expired. If I may have permission to continue.
You may respond, yes.
Your Honor, there are a couple of problems with complying with Order 19 that put substantial burdens on PBSA members. The first are the purpose-based requirements in Section 6B5. It's certainly unclear, at least, that background screening is one of the permissible purposes under 6B5. It's arguable, I guess, that background screening is a research or evaluation purpose, But given that those terms are undefined in Order 19, that there's no case law or guidance from this court defining them, and that a PBSA member would have to risk perjury in order to make that certification, that's a significant burden. It's our position is we can't comply. It's certainly at least unclear that we can comply.
Well, and if we're saying, I mean, that's still part of the problem, is that it didn't sort of go through the administrative exhaustion process because it's uncertain whether that section is really applicable to your request.
Well, I agree. It's questionable whether it's applicable to our request, because our position is these aren't requests for compiled information. If they are, let me back up. PBSA members, this dispute is not overpaying the $35 or whatever it is to get the court records. That's not the problem.
Okay.
If there were a procedure under Order 19 existing that made clear that PBSA members could comply with Section 6B5 and the license agreements as laid out by the AOC and the Bentonville Division I know there's some dispute over whether Bentonville Division can create its own license agreement, but setting that to the side, if the license agreements didn't contain these onerous provisions, such as the requirement to get permission from the government to speak about the records, the requirement to require your clients to get permission from the government to speak about the records, the ability of the court to cancel the right of access under the license agreement at any time, the destruction requirements, these sort of onerous burdens.
I guess
if those were stripped, there would be no question that PBSA would just comply with, PBSA members would just comply with the steps.
So
but it's certainly unclear whether it can.
So counsel, that answer is incredibly helpful, because if I guess, my reading is, that court just, got it wrong, and that's, 5 is inapplicable. I mean, that subsection is inapplicable. So you pull that out, and it's just a matter of them compiling the records and letting you know if it's more than an hour of their time. It sounds like you don't have an issue with that. It's that further step of having to sign a document and an agreement, and that you're not certain you meet one of the restrictions, right?
Correct, Justice Wood. It's the problem of, can we satisfy the requirements in 6B5, and then the inability to comply with the requirements of the licensing agreement.
Okay.
A background screening company has no use for these court records if it can't publish personal identifying information to its clients, and it certainly is inappropriate for it to have to go and seek government permission to speak about a topic. That's offensive to the First Amendment. That's in some ways why I urge, if the court concludes that there isn't just a statutory right under FOIA, these seem to be issues that could just be resolved through rulemaking. Okay. And it's not about paying $35.
Mr. Ramey?
Yes, Justice.
Ms. Merritt, I believe in her argument, made the case that your client's not entitled to relief under FOIA because they're a foreign corporation. I don't think I heard you address that. Can you address that for me?
Yes, Your Honor. That simply boils down to the doctrine of associational organizational standing, which I understand this court has not yet opined on. But basically, every state, as I recall, accepts this doctrine imported from federal law, that organizations like PBSA have the ability to have standing to represent their members' interests, as long as one of its members would have standing, as long as it's protecting some interest that's germane to its purpose, and as long as member participation is unnecessary. PBSA, Member Courthouse Concepts, undisputedly is an Arkansas citizen corporation, and there's case law saying that citizens that are corporations have FOIA rights. Protecting right to access records is certainly germane to an organization whose purpose is to enhance and protect the background screening industry.
I think you've answered my question. Thank you.
Are there any additional questions? Okay, if not, thank you, Mr. Ramey.
Thank you very much.
And the court will permit the appellate's rebuttal.
Thank you, Mr. Chief Justice. The inability to comply, there's no evidence in the record of that. And in fact, the undisputed evidence in the record is in Clerk Jones's supplemental affidavit in support of her summary judgment reply, where Clerk Jones testified that she knows of no reason why Courthouse Concepts or any other background screening company could not make that certification that the request for personally identifiable information was made for one of the permissible purposes. A background screen for employment purposes or any other purpose for which they are making a background screening is a research or an evaluation purpose in Clerk Jones' opinion. And she is the one who is going to receive this request and make a determination whether or not she will accept that certification.
Counsel,
It's her administrative decision.
Counsel, if you look at Section 5, it seems like the opposing counsel is saying, I don't have a problem with Administrative Order 19. I have a problem with Section 5. Well, Section 5 says it applies when the identification of specific individuals is essential. Well, he's not asking the court, their association, they're not asking to identify specific individuals. They're giving you the identity of the specific individuals. They're asking you for the case records. Section 5 was created for when, I think it was maybe his hypothetical of tell me every DUI and you tell me their names. That's when you sign the agreement, but not the reverse. So the background associations, they're giving you that name. So how does Section 5 apply that she's even correct asking for them to sign the agreement and attest to all of this?
Thank you, Justice Wood. I'm surprised to hear this argument today because their position below was always that the identification of specific individuals is absolutely essential to their request because that's the whole reason why they're asking for the records in the first place. So they've taken a 180 on this issue before the court today.
Well, counsel, I hate to say it's partially my concern that I think I've raised. Sure,
absolutely. So thinking about it today, where the identification, so if that certification does not apply at all and they don't have to make the certification, great. The bigger problem for them is that they've absolutely refused to admit that this is a request for compiled information, because compiled information is the selection, aggregation, or reformulation of information from more than one court record. And the record throughout, from the affidavits and emails from Mr. Hickman throughout, they just absolutely refuse to admit that. They don't, the information from Mr. Hickman, there's the emails that were attached to summary judgment papers and the like. They don't want to have to sign different agreements with every district court in Arkansas. I think that's what's really going on here. It's much easier for background screeners if the FOIA applies, because that's one rule, right? And one rule that gives them 3-day access, rather than an administrative order of the court that, according to this court's per curiam opinion, district courts have a lot of leeway and discretion to negotiate the terms of their licensing agreements and can impose any number of additional restrictions and that sort of thing. This court has recognized that district courts can negotiate terms and impose additional restrictions on access if the records are in fact compiled information. And so I think that the background screeners don't want to have to negotiate different agreements with every district court in Arkansas. There are a lot of district courts. And so the issue truly, I don't believe is certification. It's that they do not want to concede that this is compiled information at all. That's the litigation position. If it's not in
Ms. Merritt, I see you.
I'm sorry, I couldn't hear you.
You have less than a minute in rebuttal, and I would like for you to address something. If this court agrees with PBSA and we affirm on direct appeal, what is your suggestion? What's your contention that we should do on cross appeal?
The cross appeal should be affirmed. The court addressed that issue on the merits. I mean, we moved for.
But if we disagree with you on the direct appeal and we were to affirm on that issue with PBSA and saying that FOIA applies in this situation, what about the cross appeal in that instance?
Okay, I'm going to make sure I understand the court's question. If you agree, the cross appeal is we are appealing the circuit cour's FOIA rulings. And if the court agrees that the circuit court's FOIA rulings are correct, we still contend that the circuit court was correct on the AO-19 rulings, because those claims fail for the reasons I discussed earlier. standing, rightness, 11th Amendment, sovereign 11th Amendment immunity, and those sorts of things. They also fail on the merits because of the significant interest that the court has in the administration of justice, avoiding unduly burdening the judiciary and things of that nature. And courts always retain, as the Supreme Court explained in Nixon versus Warner Communications, a court always does
You answered
retain.
my question. Thank you.
Okay, thank you.
Ms.
And
Merritt?
let's see. Ms. Merritt, your time's expired. Let me ask you, are there any more questions?
I do, Chief. Ms. Merritt,
Yes.
I don't want to get too far afield here, but you made the argument that, you know, because this is an as-applied challenge, we have to deal with the facts that exist. I'm looking at page 20 of your brief, and you know, one thing I would point out, we have a court automation fund so that courts can kind of keep up with things technologically, so that we can improve our systems. You made the argument that this is a 2002 system. In your brief on page 20, you said that court records are kept by hearing date and type rather than by case number or individual name. And to me, that makes about as much sense as taking every letter you've ever sent to someone and filing it under L for letter. The idea that in 2020, you have this big burdensome process that takes hours to compile all this information from a list of names that are requested seems to me completely illogical. And I don't know that there's something that you can answer in that question, but I think that's something that as a court, we have to consider going forward, you know, whether or not the lower courts are using the resources they have to be able to serve the public. So I'll stop there.
And to dovetail into what Justice Womack is saying, you've referenced the fact that Benton County houses Walmart and that these background checks are going to be particularly onerous on the district court. Well, at the same time, that district court is in a plentiful part of the state, and there are a lot of resources to support it and Northwest Arkansas. So to whom much is given, much is required. And I don't know that's a question, but just dovetailing into where Justice Womack is going, maybe there should be a better use of resources there.
If I may say one thing real briefly, Mr. Chief Justice, just it does touch on what Justice Womack did say. You know, the administrative order does recognize specifically in response to what my colleague said. Compiled court records are specifically recognized. It's not simply compiled information. Section 5B1 of the order, Administrative Order 19, does specifically govern requests for compiled records. So it's not simply reformulating information from court records. AO 19 does specifically recognize that when courts compile records and submit a written request for compiled records, it can be governed. And this is exactly what's happening here. They are selecting and aggregating records from more than one case file. Thank you.
Okay, thank you, counselors. That concludes our oral argument today, and the court will be adjourned.